Hi, everyone. Good morning. This is Ifama Odolami from the Odolami Law Firm, where we fight for fellow immigrants and their American dreams. So, today I have a really great topic. So, I'm going to wait for people to come on and then we can get started. So, I hope you all had are ready for a great week. And we had a really hard weekend. September 11th is always a really difficult day. Takes us back 20 years where all the horrible thing that happened to America. So the weekend was a little rough. So let's get started. Today's topic is going to be about immigration filing for your undocumented parents. So there's several ways. This is a topic I'm going to talk about. So filing for your parents who are undocumented. And I see that two people have joined on. So let me introduce myself. My name is Ifama Odolami from the Odolami Law Firm in New Jersey, but we represent clients in all 50 states. And I'm very excited for this topic because there are a lot of misconceptions about filing for your parents, and I want to come on and clear some of them up. So we all know that if you have a child who's a US citizen and who's 21, they can file for you. Now, the issue is whether you can, if you're in the United States, you can adjust your status, which is you can stay here, get your green card without having to leave the United States. And whether or not you can do this depends on how you came into the United States. If you came in with a visa and the visa is now expired, you can adjust your status within the United States without having to leave the country, as long as you don't have any other admissibility issues, right? However, if you came into the country without a visa, then you would not be able to adjust your status uh, and without having to leave the country and do it by consular processing. So today I'm going to talk about this and talk about the options for those people who find themselves faced with this. So like I said, a lot of people think that if they have a child who's 21 and above, and the child can now file for them, and that's it. But for you to be able to adjust your status in the United States, you have to meet three criteria, right, with regards to a parent filing for their child. The first one is that you have to be inspected and admitted or paroled. So I'm going to talk about inspected or admitted. So inspected or admitted means that you came to a border, you have a visa, and you saw an officer who allowed you in. So if you were inspected and admitted, then that's not a problem. But the problem arises for the parents who came through the border without being inspected or admitted. And for those parents, there's an exception to the rule that you cannot adjust your status within the United States if you came in without a visa, if you can show that you were physically present in the United States before by December 20th, 2000, and that a petition had been filed for you previously by either a family member or an employer. It doesn't matter what happened to that petition, but a petition was filed on or before April 30th, 2001. So if you meet those qualifications, then the fact that you came in without a visa, came in through the border, that will allow you to adjust your status in the United States without having to leave the country. Another exception would be for those who people whose children are in the armed forces. They can get a benefit called parole in place. So that benefit, parole in place, allows them to adjust their status because they have a child who is in the armed forces. So if any of this applies to you or somebody you know, then that's great, because the fact that you came in without a visa will not be should not disqualify you from adjusting your status. Now, the second prong is that, of course, your child has to be a U.S. citizen who's 21 and above. That's the only time they can file for you. And number three, you have to show that you're admissible. Admissible means that the parent hasn't had any problems with the law, hasn't been arrested, hasn't done been guilty of some kind of misrepresentation or fraud that would stop them from being able to adjust their status, such as maybe they made false claims to citizenship, claimed that they were citizens for a federal or state benefit, or they've helped people cross the border illegally, or what else? What are the other things that you've accumulated unlawful presence? So those are the things that would be a problem. But otherwise, if you have been inspected or admitted or paroled, and you have a U.S. citizen child who's 21 and above, and you have no admissibility issues, you should be able to adjust your status within the United States. But for those that cannot adjust their status, then what is the answer for them? They have to do consular processing. Well, consular processing means that they have to leave the country and come back, leave the country, get their interview in their home country, and then they're able to come back. But the problem lies with the fact that when you have overstayed by either 6 months or a year, you begin to accumulate something called unlawful presence. An unlawful presence can bar you from coming back into the United States for 3 years or for 10 years. And so, of course, the issue is nobody wants to be out that long when they're trying to stay in the United States. So the answer to that is getting a waiver. But unfortunately, a waiver is a forgiveness, right? You have to show that if you were not allowed to stay in the country, if your waiver was denied, it will cause extreme hardship to a U.S. citizen, spouse, or parent. And that's where the problem lies. Because if your child is filing for you, chances are you don't have a U.S. citizen spouse to file for you, or a U.S. citizen or green card spouse or U.S. citizen or green card parent to file for you. So your child cannot be a qualifying relative for a waiver. And so it's going to be, if you leave the country, you won't be able to come back for 10 years. But I want to talk about several humanitarian pathways and other ways to get a green card and stay in this country and be able to adjust your status. One of them is VAWA. We've talked about VAWA quite a bit. VAWA is Violence Against Women's Act. And even though the acronym says VAWA, it applies to men, it applies to women, it applies to children, and it also applies to parents who are being treated badly by their children. So if you're one of them, if you have a child who's 21 and above, who's a US citizen, and who's treating you badly, it doesn't matter how you came into the United States, you can adjust your status if you get a VAWA approval. Now, the second is a U visa. A U visa is a person, an immigrant who has suffered a crime or witnessed a crime and is willing to work with the police. If you can qualify for a U visa, then you don't have to, it won't matter how you came in, you can adjust your status and get a green card. Another way to do this also, to get your green card without having to leave the country, if you're in this position, is something called cancellation of removal. Now, with cancellation of removal, you have to be in removal proceedings already, and you have to show that you have a child, a U.S. citizen child or parent or spouse who will suffer extreme and unusual hardship. And so that's a really tall order. And typically that usually goes to, showing that if either of them, the child, the spouse, or the parent has some really serious medical condition, and they will suffer if you were not around to be there to assist in one way or the other. So typically those cases, you're able to get an approved cancellation of removal. So what that means is that the judge cancels the deportation proceedings and allows you to get a green card. Another way to get a green card if you don't qualify because of the way you came into the United States is through asylum. But the only problem with asylum is that you have to file within 1 year unless something, happens, like there's a new incident that happens in the country that makes it difficult for you, makes you afraid to go back because of fear of persecution. And there are other humanitarian pathways to getting a green card. So my suggestion is, if you have a child who wants to file for you and there's a problem because of the way you came in, contact an attorney. My office helps parents all the time. We do a lot of VAWA petitions with parents who are being treated badly by their children. We're able to get them a green card through VAWA. And also the important thing to know is that your child will not be privy to this information. It's a self-petition. So you get to petition for yourself and you get to get a green card. So if you have any questions or you're looking for immigration assistance, my office is always willing to assist. 973-993-1900. Please feel free to call us. Thank you.